data management system within the organizations. And I know we are going to leave this session better knowledgeable that how we join in. So I take this opportunity to welcome Mr. Peter Kinyanjui and also Jen Wanjohi. Jen Wanjohi will assist me in terms of hosting this session. So thank you. And I give the floor to Peter Kinyanjui and Jen Wanjohi. Asanteni sana.
Thank you, Mike. Good afternoon, is it evening to all the participants. As introduced, my name is Peter Kinyanjui. Honored to be a panelist in this discussion, touching on this Act of Parliament, which has gained a lot of traction, has gained a lot of attention in terms of how organizations are supposed to adopt themselves into complying with the Act of Parliament. I know there has been quite a lot of questions, right, left, and center, and other than also the attention in the media, we have not had as many responses to the questions of the solution, and most of the employers are actually left to wonder right, left, and center to just know what it is that we need to do to avoid the consequences similar to those that you have seen on the media. As introduced, I am a practicing advocate of the High Court of Kenya, also a member of the Institute of Human Resource and a certified data protection officer, and currently the managing partner at Mwangi Kinyanjui Advocates based in Nakuru. And I'll be using this opportunity to just interact with you, who I know are mostly my colleagues in the human resource profession, to just try to demystify this act in the interest of capital. I know we've started late, and I also know this is a very wide kind of a piece of legislation that we may not be able to exhaust in the timelines. And I also know they're likely, as I expect, or as I've received from other forums, I expect quite a lot of questions. So I would want to leave these more for the engagements so that we try and look for the practical solution, since I'm very much aware that most of us at least has had a thing or two about this Act of Parliament. So in the next hour or so, I will just give an overview of this piece of legislation, and also as to help bring the case home better, I will also ventilate on a number of cases that has been decided through the Office of the Data Protection Commission, so that it informs our choices even as we move towards compliance. I will be guided by the panelists whether the questions shall be taken at the end of my presentation, but otherwise I will be guided as appropriate should I need to respond better on any of the issue that would be raised out of my presentation. So I will switch off the video to enable me to share on my screen and look forward to an engagement that will ultimately make us better practitioners in terms of compliance with the laws of the land. So I hope my slides are visible from your end. So that if there's any comments that needs to come into me, then I should be able to see that through the chat, so that I am sure that we are all following on this discussion. And perhaps just to bring this closer home, I will focus this presentation more to employment setup, but to give a rider that this Act of Parliament is enacted, is a national piece of legislation, not targeted to employment. But of course, there is a lot of focus in employment, given that we do employ, or most enterprises would employ quite a number of employees. But from the onset, I need to spell out that the Act does not only focus on employees, but ideally equally attends to every other Kenyan that may access the business premises, that may attend the business premises, whether as clients, business partners, or even strangers. The point is, as long as you have their data with you, then this Act of Parliament imputes immediate obligations on your end. And it would be important that we are well versed on it. So, and as a background, just to note that this Act of Parliament does not operate out of a vacuum. Traditionally, still matters privacy have equally been matters guaranteed by the laws of Kenya, starting with the Constitution of Kenya, which under Article 31 provides that every Kenyan or every person has a right to privacy. Again, please note, this is the Constitution of Kenya. This is not Employment Act, which means that we are now covering all citizens of the Republic of Kenya, but they all do have a right to privacy. And they also have a right not to have their persons searched. They have a right not to have their property searched. They have a right to protection of their position, and then that is not to have their positions arbitrarily seized. They indeed have a right to not have information relating to their families or private affairs unnecessarily required or revealed. And they also do have the right to their privacy not infringed. And if you look at that provision, even before we go to the Data Protection Act, which is obviously an act of Parliament now giving meaning to this provision of the Constitution, we could just look at the listed aspect of privacy under the Constitution, because you will find that every other aspect of this act should be interpreted in light with this constitutional protection. Now, we have said that they have a right not to have their persons or property searched. And I want you to look at your employment setup or your business setup. And in some cases, I know we do search. We do frisk employees. Is that an infringement to their privacy? The law or the act will help us look at whether what you have been doing in those frisking, searching, whether we do that in consonance with the provision of Article 31, which protects every Kenyan against such arbitrary searches. And I'm sure you've even seen that even through the police, for instance, even when investigating crimes or crimes. If they need to search your property or your person, they need to get a search warrant from the court. And before they get it, they need to have demonstrated or convinced a judge why it is that they must be allowed to infringe, or why they must be allowed to remove the right or the protection given by the Constitution. And they must show that there are reasonable ground that this person could be hiding something, or there could be something which must be specific that may have been concealed either in that car or in that house or in the person of someone that maybe gives them the right to now get to search them in the interest of ensuring that no crimes are perpetrated. So generally, you'll be asking yourself, how are those searches done? Because if the Constitution gives this Kenyan, and I would want to emphasize Kenyan, because we employ adult Kenyans, and we do always ask them to demonstrate that by asking them to give us their national ID cards, which is a testimony that they are adult Kenyans. So The employees that you do have from the onset are adult Kenyans, and this is why we start with their constitutional protection through the Constitution of Kenya 2010. Now, whatever else that you do pertaining to these adult Kenyan in administration of your operation or rules and regulations must always pay tribute that these are adult Kenyans protected by the Constitution. Look at the aspect of that they have a right to keep their family and private affairs private, if I may use that word, that they have a right not to have information about their family or private affairs unnecessarily revealed. And I want you to use that maybe to give an example in employment. I want you to look at our biodata. Do we ask our employees to disclose their marital status? If so, what is the basis? Remember, the Constitution has protected them against telling you about their family or private affairs. But here you are asking, are you married? Do you have children? Where does your husband or your wife work? Ideally, you're already asking private information. And as we proceed with the more information, let me say, or the meat, because this is just a skeleton. As we go to the act itself and look through the meat to implement or to safeguard these rights, you will be able to see whether indeed what you ask of the employees is indeed infringing. And if it is infringing, you must have a justification. Remember, there is no constitutional safeguard that has no exception. There is no right that is absolute. And therefore, from the onset, I'm not saying that you cannot search. You can search, but you must have valid ground for doing such kind of a search. I am not saying not to ask your employees to give you details about their family, but I will want you to pause there and tell us, why do you need it? If you can justify it, then indeed, then we'll go to the next part of how then you get this information and so on and so forth. Right to have communication protected. Again, I've even found situations where employers will even go to an extent of asking employees to give up their phones, to go through their text messages, to go through their WhatsApps and all that, to go through the call logs, maybe to just establish why the bill on their company line is going very up or they're investigating something. Here, it will be a takeaway from today's engagement will be to balance between the mischief that you want to protect vis-a-vis the exposure that you will expose the company or the business into by violating their right to privacy. If you find the operational requirement outweighs the risk, then perhaps you're justified to take the risk. But if you find that maybe all that you want to check is why someone spends so much on a phone, on a company phone, and in doing that, you're having to comb through their bills for the entire month and seeing who they have been calling, what time they have been calling, you will find that the mischief is too minor, but the exposure is too big. And that is the checkpoint that you should stop and ask yourself whether you indeed want to proceed with that policy or practice in your workplace or your business premises in light of the dangers that you have seen being occasioned by such violation. So under the same constitution is providing that every employee has a right to have information about them being kept in an accurate way. And if it is not accurate, then they have a right to have it corrected. And if you don't need it, they even have a right to have you delete if it is untrue. Remember, I have not touched yet on the Data Protection Act, but already we are talking about the Data Protection Act, or I mean the data privacy, or the privacy of Kenyans, which is already enshrined in a constitution that was promulgated in the year 2010. So the whole aspect of data privacy has been with us for a very long time, only that we have had Kenyans enforcing this through the High Court, because before the institution now to the commission that was set up as we come to interact with it was put in place, being the Office of the Data Protection Commission, then anyone who would have had their right to privacy violated would have gone to court, and it would have been the court that would have awarded whatever damages or compensation for such violation. So from the onset, I would say this is right to privacy is not introduced by the Data Protection Act, but is anchored and very well anchored on the Constitution of Kenya. But as always, you realize the Constitution just gives a skeleton, and if you want to give more meaning to what the Constitution provides for, then you have to go down to the Acts of Parliament. You have to go down to regulations, which we refer to as subsidiary regulations or legislations, and then all the way to your policies in the company, and even to your practices that may not be codified. So the Constitution of Kenya, is the supreme in the hierarchy of the laws of Kenya, of course, followed by Acts of Parliament. There will be subsidiary legislation, and therefore your policy as a company, your policy or requirement as a business is so insubordinate and so inferior that it cannot introduce a rule, a practice, or a policy that stands as an affront to what is guaranteed by the Act of Parliament and what is guaranteed by the Constitution of Kenya. So always whenever I interact with practitioners, I always caution them against over-reliance on your policy. It is very, very, very consistent and often that whenever you ask a human resource practitioner, why are you doing this? On what basis are you doing this? Their answer is always, that is what our policy provides. So from the onset and from the interaction through this act, you should always know that it is not what your practice or the policy provides for. Because if it violates the law, if it violates the Constitution, then even if that policy is null and void from the onset and cannot be used to protect cannot be used to protect capital in the event of someone suing the business or the company in court for violation of such rights. So this act, the data protection, came into force in the year 2019. And you remember it was signed very fast, because at that point, the government required to gather information about Kenyans in what is referred to as Huduma number. On one side, there was that justification that we needed that for purposes of maybe national security, for instance, which is a noble ground. But at the same time, some people felt that the data being asked when registering for this Huduma number was so intrusive. And there were questions looming about whether the government could be trusted and whether it had enough mechanism to make sure such data, even if procured for the right reason, whether that data would be safe against sharing with other persons. And you realize some non-governmental institutions and human rights bodies went to court challenging the entire aspect of Huduma number, and in clearing that the government has a right to take up such data for its purpose, including national security, very clear guidelines were given that the gathering of that information should not proceed until the government put up proper laws and legal framework to ensure that that exercise was being conducted within the law and while paying tribute to the constitutional protection under Article 31 of the Constitution that guarantees Kenyans' privacy against intrusion. And the Constitution guarantees Kenyans even against the affront by the state itself. So even the government itself cannot come up with a policy that goes against the constitutional framework. And this is what I want us to take up with a lot of weight as we come up with policies and regulations at the workplace, that even the government of Kenya cannot be allowed to do anything that violates the Constitution. So what about our policy? Clearly, our policy being even an inferior document, clearly our organizations being even in terms of the might, if I might use that word, as compared to the government. If the government can be stopped, then let us be very clear that our organizations can be stopped in the event they come with any rules or regulations that violates the Constitution. I can give an example of a matter I've been consulting on, a very basic matter that has now taken a very different angle. And this is a case of a livestock manager in one of the companies that is in the business of doing ranching. And at some point, or rather the company policy provides that at that level of responsibility, that manager must live within the ranch because the herd could be attacked. This is in the Laikipia conservancies, where sometimes it is not unusual to have either a wildlife attack on the herds or something. And at that point, when this employee wanted a job, of course, they signed that contract very quickly, and they have been working for more than 5-6 years until this person married. And at that point, this manager thought that it was no longer conducive for them to continue living within the premises, and they would wish to raise their family outside the company premises. Now, I would want you to pause and reflect on that, which is an otherwise very harmless kind of a situation. On one side, the company requires you to live there because you could be called out anytime to coordinate a thing or two. And given the locality of where the employment is situated, it is not somewhere that you can make a call and have someone come in within an hour or so because of the vastness of these ranches. So they have provided a house that you're supposed to sit in due to the nature of your job. But here, there is my requirement to privacy that I don't want to raise my family within the ranch. I want to stay out there. And this brings in a stalemate. And I know this is a matter that is likely to go to court because it ended up with separation because the employee could not agree to continue living in, and the employer felt that it continues, that his absence was leading to incidents that were occasioning losses to the enterprise. So again, let us look at it in that very basic way, because it will help us understand the law as we have, so that we make policies that pay tribute to the privacy, while also ensuring that they make sure that our operations are not in any way compromised. So this act came in, and there were regulations that were also enacted following that act, which included the data protection regulations, the data protection, complaint handling and enforcement regulations, and also registration regulations. These are the regulations that provides for every data controller and data processors to be registered. The Act also introduced the Office of the Data Protection Commission, which is basically the organ that enforces the Act and oversees its implementation. So during this short presentation, we'll be using the terms data controllers and data processors, and maybe at this moment it will be good for me to distinguish. I know this causes quite a lot of confusion to many players or implementers of this act. And here, if you as an organization, you are the one who determines the means or the ways that the data is collected or processed. And here processing, I can give a very basic example. Like for instance, you are an employer, and out of being an employer, you are the one who requires that every person who has to work for your organization must give you their ID numbers, must give you their NSSF, they give you their NHIF, they give you their bank accounts and so on and so forth for your own purpose, for employment purpose. Then you are a data controller. You are the one in charge of what data you ask and how they are dealt with within the organization. This is as opposed to a data processor. A data processor, again, in a palatable manner that makes us understand this better, is a person who equally gets this kind of personal data from persons who we will be referring to as the data subjects. But the processor would be acting on or in the interest of another organization that now consumes the information collected by the processor. Here, let me give an example. Like for instance, you have an organization that runs your payroll. Now you realize that they have information, all the information similar to that which you have as an organization or as the employer. But unlike you as an employer who is the data controller, for them, they only have the information for purposes of processing payroll as procured by the controller and actually paid by the controller for it. If today you want to install CCTVs, most likely you're not the one who is going to be doing the installation. You, as the data controller, maybe for security reasons, will shop for another organization that will be collecting information or data belonging to your employee. But that processor has no interest in that data. For them, it is not for its own security, but they have all the videos or the footages that they are collecting through their technology, but for the consumption of the data controller who will review it in the event there is an incident of security or otherwise. And I want to believe by that very simple distinction, you are able to look at then as an organization, even when you go to the registration, you need to first of all classify yourself. Are you a controller or a processor? There are cases where you find that you could be both. By extension, every controller is a processor, but not all processors would be controllers. And in this case, I'm saying that if you are the organization, it means you must, by using the word processing, it means you take those ID numbers, you key them into some software systems, you are able to transfer them, to share them, and do all that, because that's what we call processing activities. There is no way as an organization you can do your functions without processing those data for your purpose. But for the processors, like you said, they are limited to just doing what is necessary as per the contract of the controller who would have told them how much do you collect, how you cannot share it with someone, you cannot keep it beyond this period. All those instructions are instructions to the processor from the controller who is the one consuming the services of a processor. And maybe on that point, just to be very clear, is if you are an employee of a data controller, I have had these questions come to me over and over, where maybe a HR person or a data entry clerk or a finance person is asking, do I need to be registered? Because I'm the one who is keying these details into their computers and then sharing and then storing and then blah, blah, blah. And the answer is no. If you are an employee of a controller, you do not need to be registered. It is your company that requires to be registered. Then those people doing the processing activities are agents of the controller and do not need to be independently registered with the Office of the Data Protection Commission. So it is important I clarify that, because I know those are mainly the questions that are likely to come in to be sure about registration. So when we talk about the personal data, it's also important that you do appreciate that we are not talking about any form of data. It is not a generic data. It is not statistics. Personal data is information that, as the word denotes, is personal to an individual, and therefore, if disclosed to a third party, then it can make that third party identifiable. So that by giving my ID number, then you will know that this is an ID of Peter Kinyanjui. If you get to see my photo, even without the name down there, you will know this is Peter. If you're to be given an email address, you will know this email address belongs to Peter, because nobody else has that email other than me. If you're looking at all the other details that we have talked about, the PIN, KRA PIN is very specific. NSSF, very specific. NHIF, very specific. Name them. If the data you're talking about, whether used as a standalone or when put together with other data, can lead to an identification of a particular person, then that is personal data. So again, it is not about the number of cars you have. It's not about if you're in a flower farm, the number of stems that you export, or if the products that you deal with, and so on and so forth. It is about information that could be used to identify people. Okay, and having said that, the person who would be identified by that information through the Act is referred to as the data subject. So if I'm giving you vehicle registration KCX 042Y, can it be used to identify a person? Most likely we will know the person who drives this car is Mr. XYZ who lives here and works there. So that information is private, is personal, and should be protected. Remember, this act comes at a point when most of the criminal activities has gone to information, or has gone to, it's actually smart, if I must say. Most of the robberies, most of the criminal activities will be carried out from Tandao in social media. Most of the con games, as I'm very sure most of you would have gotten some text messages, some phone calls, or someone who is either telling you that they send that money to you erroneously, to me a Kohi number. Somebody will also send to you a message where they are telling you to maybe rise up and go and vote for them, and they're actually identifying you by your name. This is basically the mischief that this law is supposed to come in and make sure that a person who obtains your data, first of all, obtains it legally and consciously, but then also uses it for purposes consistent with the reasons that they had procured that data from you. And yeah, the examples are many, and they may not be limited to what is projected on the shared screen, but ideally you should know that the way to determine whether data is just generic data or personal data would be to ask, can it be used to identify someone? If I'm using my name, Peter, would you say by saying that the person who did this comes by the name Peter, would you have given out my identity? Most likely many of us will say no, because how many Peters do we have in the whole country or in the whole world? So it will not betray my identity, where I live, whether I'm a Kenyan or Ugandan or in the Americas. So if it does not come in, then the level of harm of that information is minimal, and that would not be the focus of protection. But most likely if you use Peter alongside Kinyanjui, then now together, many people will be able to reduce those so many Peters to just maybe a few Peter Kinyanjuis. And maybe if you give another form of information that this Peter we are talking about is an advocate, you see you are still zeroing down. At this moment, you're using different sets of data which put together, they are going to identify somebody, and we can actually come for you, including where you live or where you work. And this is now what you're saying, that such information definitely belongs to you as the data subject, and they should be dealt with in a way that is very guarded because of their potential to cause harm and even to have people killed, other than causing a lot of financial harm to people, simply because somebody shared your phone number. Yeah, and out of just sharing your phone number, it has been used to perpetrate criminal activities, and we can call you. By calling you, we are able to know your position, we are able to know where you live, we are able to know your names. I can send just a few coins on your line and I'm able to get an email giving me your full names, and so on and so forth. So again, let us look at that in terms of going down, look at biometrics. You have informations maybe that allows entry to someone before they come in to your workplace, maybe their thumbprints, maybe the eyes, maybe the facial recognition or the palm. Those information are unique to a person. And therefore, the moment you have them, you know that you have a duty to make sure that they are kept and safeguarded in line with the protection under the Act. Medical data, DNA, race, religion, sexual orientation, any data that can be ascribed to someone and can make them identifiable qualifies to be personal data, and therefore the subject of the Data Protection Act. I have explained the difference between the data controller and data processor. We'll, again, if it is not clear through the Q&A, I can re-emphasize, but I'll simply say that a data controller is the entity that is determining how and why the data is being procured and why it is being processed. You have taken an ID. When this employee comes in, they come with a photocopy of the ID. But then you are the one who determines that I may need the ID in the hard copy, but I need to take the ID number and pick some information from that ID and feed it into into a computer. So I take the name, type it in, you are processing already. Take the ID number, put it there, year of birth, put it there, gender, put it there, already you are processing. You are the one who determines the purpose for search. Maybe you will tell me that why you're taking the age is because you need to determine when this person will be due for retirement. So you're the one who's saying, I must know the means, I must know the purpose. You're the one who wants to know the gender of this person, because perhaps you have got work that may not be done by a person of a different gender or either gender. So you are the one who is determining what you're getting and the purpose for which you want that data. This is as opposed or as contrasted with a data processor. A data processor will be doing this on behalf of the controller. And therefore, they are not the one determining what to get and how to get it. It is the controller that has decided that the way we will get data is by procuring CCTVs. So the data controller decided that we need to install CCTVs and then called a data processor whose job is to install CCTVs to come and do that on their behalf. And by that means that maybe if the data controller wants this information retrieved, he will be calling them and have them install the gadgets, blah, blah, blah. So again, I want to believe that is important so that you know as a business, whether you are a controller or a processor or you are both. If you're both, you need to be registered for both with the Office of the Data Protection Commission. But most of the organizations I know will either be registering as controllers or processors. Now, just to, again, have these acts come home, I would want you now, having known what we are referring to, having identified what we call personal data, what is personal data, having identified that we inevitably may need to collect this data for our purpose, then the Act borrows from internationally. And perhaps that is part of what I needed also to do as a way of introduction, that this act has what we call extraterritorial effect. It means we are not talking of only Kenyan. We are talking about anyone irrespective of their nationality. Yeah, we are talking about a Kenyan who will be flying to the Europe. Yeah, so it really does not matter whether the violation of their data happens in Kenya. It also does not matter whether that may be national carrier, Kenya Airways, that may be ferrying or carrying the different people or persons from different nationalities. They have a duty to ensure their personal data is safeguarded irrespective of national boundaries. And therefore now, that being so, this act applies to you, whether you're in Europe, whether you're in Americas, whether you're in Africa. Now when it is gaining traction, they apply to people. It is actually taken as a human right, irrespective of the nationality of that person. And now that you are dealing with this information, you need now to know what are the safeguards that will make sure. You need to know what are the safeguards that will make sure that how you do collect and process information, whether it conforms with the principles under the Data Protection Act. Ultimately, this is what will save your company from the hefty damages that you found meted on organizations for violation of personal data. And therefore, if there is one thing that will be important for you as a takeaway, is to know how you interrogate every processes that you do take, how you interrogate every set of data that you obtain from people. You interrogate it against these principles and get to know whether then what you're doing is within what can be said to be responsible handling or processing of personal data. And the first principle here would be the principle of lawfulness, fairness, and transparency. Now, ask yourself, when you look at lawfulness, ask yourself, what you are asking, has it been sanctioned by the law? Is it a certain act of parliament that provides that you must obtain this data from either your clients or your employees? Now, let me assume you work in a hotel industry. For national security, you are required to ensure that you get data of all the persons who checks in into that hotel. So you must ask for their name, their ID number, and all that. These are requirements of the law. And therefore, you do not have to worry about the reasons for asking this data. If it is the law that requires you to get it, then you must get it without worrying whether you are getting too much or for what purpose. If the law provides that every employee who comes in must give you their ID, must give you their NSSF, their NHIF, their PIN, and by extension, maybe email addresses, all that, then that is information that is required by the law. And therefore, we remove the aspect of must you have it. Here, indeed, the law says you must have it, and therefore there is no shortcut to that. But now the fact that you have it, it takes you to the next level. Now that you have it, how do you use it? That principle tells you, as much as the law requires you to have it or mandates you to have it, you must use it in a manner that is fair and transparent. Transparent means, and this is part of what I know we may not go very deep into all this. This is what we'll be interrogating, for instance. If I'm coming to help your organization assess whether it is compliant with these principles, I'll be looking at, first of all, what data do you have? Then transparency is, did you explain to the person who gave you the data? Did you explain to them where you need it? Remember, if you have not explained, then it means you have a blank card to use it the way you want, which is a fallacy because the law still puts you, makes you responsible on how you use it. So I gave an example. You are asking your employee whether they are married. The question is, why are you asking them? Tell them that we are asking for your marital status simply because of for this reason, that we have a medical cover. And therefore, as part of us getting you into that scheme, you need to give us the details of your wife, the details of your children, the ID. We must even ask you about some medical conditions about them for the purpose of medical cover. Now, if you use that information for any unrelated or for any other reason unrelated to medical cover, then you fail on the test of transparency and fairness. And if you fail on that aspect, as you will see, there are consequences to that. That the way you, as much as you obtain my data legally, I am the one who gave you my ID, I am the one who gave you my phone number. You obtain them legally, but you have used them in a manner that is unlawful, and therefore you fail on the first test. And the first test is closely related to the second one, which is purpose limitation. You go to an M-Pesa outlet, they ask for your ID, they ask for your phone number and all that. You ask yourself, what is the purpose? The purpose is for you to carry out a commercial transaction. But then what happens after that? Is the data safeguarded and only used for purposes limited to that withdrawal or the deposit? If it is, it means that M-Pesa outlet or agent is treating your data in consonance with the principles of data protection. But then, wait a minute, somebody comes in and they want to it is during the campaign period, like we all went through, maybe a year or so. And someone wants to get a digital database to do bulk SMSing. So how do they know the people who mostly would be resident in that area? They go to that M-Pesa outlet, they do a photocopy of those books. And because the agent does not ascribe to this principle, they derogate from the purpose that they have that data for purposes of commercial transactions for that M-Pesa. But they decide to use it for a different purpose. They sell it out. Before you know it, you have a text message from your MCA, you have from your governor, from your senator, actually identifying you by your name, dear Peter Mwangi Kinyanjui, kindly turn up for voting for Mr. X or Madam XYZ for the governor. That is a very clear derogation of that principle, that you lawfully give your information for a specific purpose, but then that information is now used for a different purpose. You have gone into an entertainment point. You take your meals, you take your drinks, and then eventually you pay for that transaction using your M-Pesa. Now, it means that that restaurant or that bar has information, about your name, your phone number. What do? They key it in, and therefore every weekend they will remind you through a text message that today we have a Mugithi evening, today we have this, today we have that, and you get that text message on your number. Is that a violation? Yes, it is a violation of the principle of purpose limitation. And the examples are many, 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 many of where now we find a very clear violation of the data, which is now being used for a different purpose. And as we go by, maybe we'll sample an example or two to just ensure that you appreciate the consequences of such violation. Because ultimately, if that data escaped from your organization, and I want you to look at that security person who records all those details in that black book at the gate. And the question they ask, once Peter wants access to your organization. So give me your name, nampatia jina yako, number ya kitambulisho. They ask for it religiously as if they are entitled to it. Nipatie namba yako ya simu. They are not even explaining why they need it. Yeah, they, even without asking you, record the number, the registration number of your vehicle. They feel that they're entitled to it. Before you know it, they open Mulango ya Gari and they want to search. You see, out of that transaction, and I'm sure most of you are now reflecting on what happens at the entrance, at the gate, which is the first interface with the visitors of the company, you already appreciate the violation that could be going on, and therefore the exposure that could be occasioned on your organization. What if I want to get information about your employees or your visitors? How difficult is it for me to go and get a photocopy of that book? How much will it cost me? And then immediately I use it for my purpose. It may be commercial purpose, maybe promotion, maybe political reason, yet I give my information to a security person for the purpose of access to the premises only. That is the second principle. Look at the principle of data minimization. Here, a responsible organization that is handling personal data should always ask themselves, are you gathering excessive data? Because the more you have, the more are the potential dangers of it getting to a third party. And the Act puts strict responsibility on you as an organization. And why, just to explain that, it means that it does not matter how the data left. You cannot come and say that it is that security guy who sold it. You cannot come and tell us that it was in this laptop that was stolen from the company organization. You cannot tell us that it is your employee who decided to sabotage you and decided to access and shared it with someone. That will not be the concern. You have a duty to ensure those things don't happen and to put safeguards that ensures that that does not happen. So one of the principle that you should observe to minimize those kind of risks is to ensure you have only what you require. You have only what you require for your purpose. What you don't require, don't take it. If there is another alternative way of achieving your purpose without asking for personal data, do it. And let me give you an example here. That here, what you want to address is employees misusing the company phones that they are given for official purposes. So they are making so many calls out there of social nature or non-business purpose. Fine, you have a reason to want to control that. But then how do you do it? In some company, they will require to be supplied through the statements of all the calls that have been made through that line for a whole month for purposes of assessing whether those calls were business calls. But now look at the information you have brought in for the purpose of addressing an overuse, 500 or 1,000 or 2,000 shillings. You have invited into your premises all the data for a whole month. All those are personal data. They all have a potential of leaking because they have to be processed through this person, through the account person, through all that. And the potential of those data being used or escaping or being stolen is very high. In short, you fail on the principle of minimization. Bring as many data as you require for your purpose. In my classes, because I do a lot of this training internally to ensure that your managers, your security guys, your finance people do understand these principles to make some, because it is one thing for you as a practitioner or maybe owner of the business to know all this. But if this information is not taken to the persons, that security guy who is asking for all this information and who will refuse to sell it or will make sure it is guarded, if this information does not go to them, then the information you may have at your level, you may find that it will not protect the organization. So what we do, the right to information is once you have put in these policies, then they has to be taken down to the persons who are the implementers. And this has to be done through trainings, through awareness programs to ensure that it is taken in and these persons do sign. Because by doing that, you limit liability just in the event there is loss of this data. So minimize. If you have a security issue in your home premises and you decide that you want to bring in a dog, maybe to ensure that those intruders do not come and steal right, left, and center, then you have a proper reason, you have a purpose for buying these German Shepherd. So it is lawful what you're doing, you have a right to protect yourself. But then, how many German Shepherds do you bring in? If you bring more, the more they are likely to escape. And if they escape, they cause people harm, you will ultimately be liable. So here we are saying, make a conscious decision. You have security lapse, you have identified legally for your protection that you can bring in a dog to protect you. But then, unfortunately, you have brought in a very dangerous German Shepherd that you know has the potential of escaping and harming a neighbor's child. Therefore, it brings you to the next principle that you have all this data. It is your duty to make sure that the information about that data, you can be able to demonstrate it. If tomorrow I am doing an audit on your data processes, then it is your duty through your documentations, through your passwords that you put in place, firewalls, policies, access control. It is your job to show me through the principle of accuracy, accountability, and I will marry that with integrity, that the data you have is dealt with in a manner that ensures that the personal privacy of the owners of the data subject is observed. Here, when I talk about integrity and confidentiality, I will be asking you, who has access to employees' files? How are they stored? How is that cabinet to ensure that an unauthorized person does not get access to it? What about if it is electronically stored? What is the strength of those passwords? Can anyone, a third party comes in, push in that memory stick and copy all your payroll? Is there anything in that device that restricts that? Do you have levels of who can access what kind of information and who cannot? All these will be showing and demonstrating to either the Office of the Data Commission if there is a breach, or even me as the owner of that data will give me confidence that the information I gave you about my health, because I was unwell and you asked me to give you proof that I was unwell, and these employees have given you documents. Some will even give you treatment notes, some will give you discharge summaries, some will give you their medications, and you have it. Remember, the purpose you're asking for it is for you to account for that sick-off. That is the purpose. But then, do you have excessive information? What should you have asked, for instance? One principle of purpose limitation and confidentiality here, integrity, is, for instance, someone has been unwell and they have the first person, like I said, the need for us to make sure that we bring it down, to make sure that our team are fully informed. The very first person that this employee who has been away for a day or two will be in contact with is likely to be your supervisor. And the question they will ask is, you were not at work yesterday, ulikuwa wapi? And the answer from your employee will be, I was unwell, nilikuwa mgonjwa. What is likely to be the follow-up question? Ulikuwa mgonjwa wapi? Shida ilikuwa nini? Mfanyikazi amesema, my child was unwell. And then the next thing is, I need to know mtoto alikuwa mgonjwa wapi. So you start inviting information. They give you their treatment notes, their discharge summary, their medications, or where they went to buy them. You have it. First of all, you have failed on the principle of data minimization. That information is excessive to justify a day's absence. It would have been sufficient to just get a note from the doctor simply telling you as an employer that this person was unwell and I have allowed them 1 day off. Meaning you have not known what they were suffering from. You have not known about their children. You have not known about so much. So this is where we fail. We ask for so much information that exposes you so much to address a very basic mischief. Someone is applying for paternity leave. What do you ask for them? To just make sure that you not have everyone abusing that right. You start asking, you come up with a policy that you know you can only go for paternity if you bring in a notification, and that notification, the person listed there as the mother should be in our database, should be in the company's record. And I'm almost certain, because I have interacted in a lot of trainings, I'm almost certain that I'm speaking to many of you who still have those policies in your books, that the person, if you are to take the 14 days paternity leave, it must be on account of that lady who is in our database as your spouse. Now, here, you're asking for very private information. Go back to Article 31 of the Constitution, provides that I have a right not to have information about my family affairs unnecessarily revealed. Now, you're telling me I must tell you, first of all, that this is my spouse. Then number two, I must also come and tell you that I have gotten this child with this spouse who is registered in your record. Yet the law does not say that. The law simply says a male employee is entitled to 14 days paternity leave as long as I demonstrate that that child is mine. The law does not put it on me to demonstrate that who I got that child with. It is the same for maternity. It does not matter whether the lady was made pregnant by the husband who is in your record. That is immaterial. They are pregnant, they have a right. So what should you be asking them? It's not details about who made them pregnant or who they got that child with and whether it is the registered spouse or not. What you should simply be looking at is a very basic document from a registered practitioner or a midwife as per the Employment Act that tells you very clearly if this lady is pregnant or is expectant and has a right under the law to proceed for maternity leave. So again, look at the principle of minimization so that you only have what is necessary. And once you have what is necessary, now look at the principle of integrity. And that is the safeguards that you have put in place to ensure that unauthorized person do not access data that they shouldn't be having. Now, then after that, you have received the information. How long do you keep them? You have received that book from the gate. It is now full. And it is kept in some archive. Under the principle of storage limitation is how long do you keep it? Because the more you have it, the more the possibility that it could be, it could get into a third party who is not authorized and cause harm to people. So you asked Peter Kinyanjui, who wants to access your premises for their ID, for their phone number, for the car registration, has been recorded on that book. So now the question is, I have left. You have even given me a note and you have told me, go and the person you are seeing should sign here and you bring this paper back so that I'm able to record what time you left and I ensure that it is and that it's signed off and I check on your car again, I ensure you have not stolen anything from the company. And on that basis, I allow you exit. Now I have gone. I came for a training. I have trained your people. I have left. How long do you still need to keep that information? That now brings into the principle of storage limitation. Only keep it as long as the law requires you to keep it, or as long as you need it. You have received CVs. You are recruiting for a position of an accountant. You have received 100 CVs that all have all those personal data, the name, the photos, the email, the address, the gender. It goes on, it has some for referees. It has some, a lot of immense data that you do have in 100 or 200 CVs that you got. You only need to fill one position, and you have filled it. And you will never employ 200 accountants. You only have a position for one. Why are you keeping 200 CVs with personal data for a position of a CV, and you're not a recruitment agent? Because if you are a recruiting agent, you can ask people that, let us keep them in our database. Give us permission to keep them in our database, just in case another client of ours is to look for similar skills. Now, for you, you are an employer, and you have only 1 or 2 positions for a HR manager. Why do you have CV for 500? Excessive data, you fail on the principle of data minimization. You are keeping it for the duration you don't need. You fail on the principle of storage limitation. It should have been discarded as soon as you filled your position, because the moment you fill the position, you fulfill the principle of purpose. It was to get an accountant, and you have gotten an accountant. Why do you still need them? You fail on that principle. So the generality of this informs you on how to treat your data in every processing activity, be it how you collect it, be it how you transfer it, be it how you store it, whether electronically or physically, be it on how you discard it eventually. All these are chains in data processing activities, and they must be carried out in line with the principles of the data protection. If you fail to do that, then you expose your organization to serious consequences. So I have spent quite some time on that, because this is what now will dictate. This is what will now dictate how you eventually model your policies and your rules, your restrictions, and guide the persons who also are responsible for every aspect of these processing activities. And that is the only way that you should be able, through your policy, to write to the whole world and say that you collect employees' data and handle it in line with the international principle of data protection. And therefore, you will have people do business with you knowing that they bear no risk of their data getting to the wrong hands. The next part that we'll be looking at, again, I know I will share to the team. I don't know, maybe they will advise us by the time we finish on how we are going to share the notes here, because some of them I suddenly have to rush through them. But here we have rights of the right of, in the Act, you will find that we have a right of data subjects, and we say the data subjects are the persons who the information you have could identify. So under the Act, they have a right to be informed. And look at that example I've given about your soldier at the gate. Do they tell us why they want my ID? Why do they want my telephone number? I have a right to be informed. Now, if I'm auditing you, you have a duty to demonstrate that the data subjects are informed. How can you do this if you have not come up with a data protection policy? You have sensitized your people on it. They have signed that they are aware that the company will be collecting this data and they will not share it with anyone else. And if they need to share it, they will come to seek consent from me, and they will keep it in a way that it is not accessed by unauthorized persons. If I come today, you call me to come and carry out that kind of an audit, and I speak to your people, I will tell you whether your employees are informed about your data protection policy. Just like if I was to ask them about safety, I will ask them, have you been trained on this? Have you been trained on this? Do you know where the fire assembly point is? Do you know? They will tell me, yes. If there is an accident, do you know who you will call? They will tell me, yes, there is a number that is put in here that we know this is the first aid on duty. That demonstrates a workforce or a clientele that is informed. Can you say that about data privacy of your employees, of your client? If no, you are not in consonance with the spirit of the Data Protection Act, and that needs to be an immediate priority for you to have the policy in place, and most importantly, trained and owned by these people who own the data. They have a right to access their personal data. Remember, this data does not belong to you as the controller. This data belongs to me as the data subject. It is information about my family, and I want to underline my family, not the family of the data controller. And therefore, I have unlimited control on how that data can be used. I am the one to give you permission. That file that you have kept there, that employee file, does it belong to you or does it belong to an employee? A lot of us in my interaction will tell us that if an employee comes in and says, nataka kuona file yangu, we immediately recoil. And most of us actually deny and start asking us questions, kwa nini unaitaka, for what reason? And here the law is saying, I have a right to access my personal data. And this is the reason you find that even where we have our data given to the government, for instance, if you want to know whether you are registered as a member of Azimio or Kenya Kwanza, you will talk to the registrar. You just need to do a text message to the registrar of political parties, and they will send you a text. They will tell you you are a member of ODM. You have a right to access. But that right of access also comes with a correlating right to correction, so that if you find that the information that is there is reading that you belong or you are a member of ODM and yet you are not, or Jubilee and yet you are not, then you have a right to have that organization correct, update your information, and the Act actually stipulates that that should be done within 14 days. The right to access should be within 7 days and should be free of charge. Don't charge me unless I am asking for very voluminous kind of information that in that case, you can say it occasion financial constraints to you. But if it doesn't, you shouldn't be charged and it should be availed to me within a week also. The right to correction also, we will correlate with the right to deletion. And deletion, it means here I can tell you, I want you to delete that information. And for those in employment, maybe just use an example, because I also said I'm a HR practitioner. It will not be an issue for an employee to come into your office and tells you that I want you to change, Badilisha, the information you do have about my NHIF. And they tell you that nataka utoe huyu, nataka uweke huyu, tumewachana na huyu mzee, nataka uweke huyu. That is express instruction that you immediately must delete that person amekuambia amewachana, and you substitute it with the person mwenye amekuambia, this is now my new person who should benefit from my NHIF. Again, don't start asking so many questions. Don't start making it so difficult unless it is required by the law. If it is the NSSF or the NHIF that requires you must have an affidavit, then tell them, I will do this, but remember, the requirement is you must give me this or that. After a couple of months, they come back to your office when HR, Unakumbuka ile information nilikwambia utoe, nataka sasa urudishe, tumerudiana na huyo mzee. Again, your job is to execute. Make sure the information you are holding is accurate and that the data subject owns it, because it is not what you have in your biodata that is indicating that somebody is a single, because that's the information they gave you when they were employed 3 or 4 years ago. Now, that information is no longer correct. They have since married. This is a proactive duty. You don't wait for them to come. You ensure that you encourage them to come and review the information that you're holding of them and to keep updating their statuses as necessary so that you discharge your duty to ensure that the information you are keeping is accurate. Data portability, again, is someone may ask you, instead of going to company B and they are being asked for the same information, I want to switch from Safaricom to Airtel. Safaricom has all information about me. Under this right of portability, I should basically be able to tell Safaricom, can you give information that you're holding about me to Airtel for them to be able to have a line registered in my name. And for you, Safaricom, or the other way around, I want you now to delete that information because I'm no longer running your line and therefore it is of no use to you anymore. That is how much this information is kept to the hands of the owner, who is the data subject. Automation, again, you should not occasion harm to someone because you have automated your system. Someone has a right to not to have decisions made by a machine. So here you have attendance, biometric attendance, and somebody is telling you, I was working, and your machine is saying, angalia machine inasema haukuingia kazi, you didn't clock in. Now, which information should you go with? You have your supervisor who is actually telling you, ni kweli huyu mfanyikazi siku hii aliingia na alifanya kazi. You have your machine here, your biometrics and the clocking in, which is imeandika hakuwa. Which one do you go by? It should be that machines can fail. And therefore, if machines fails, you have to go for another human interface to ensure someone does not suffer an injustice simply because you have placed decision-making in the hands of a machine. And we can go through this and this. There is a lot of robust, there are a lot of robust rights there, a right to object. I can tell you, I gave you information for you to use up to this extent. You can now not use it for this other. Nilikuambia tu information uliniambia is for processing my salary. Now you can now not also use that information to share it with a circle for purpose of my loans. And I can object, I can tell you, don't share. I gave you for this purpose, please limit yourself. Yeah. And when it comes to a minor, just know that whenever data you are handling for them, they are sanctioned. The minors cannot give consent. Persons who are disabled and especially mental disabled cannot give consent. And therefore, a person who is a guardian must be able to give consent on behalf of that minor. And you will see one of the consequences of one of the organizations that did not follow that rule with very expensive consequences. Okay. It is important to say that there is no right that has no limitation, that is absolute. And here we will be looking at this using the aspect of consent. Remember we said a data subject should be able to be asked for their express consent if you need to process the information. If you want me to give that ID to you, you want to keep it or to store it, you want to transfer that information to a third party, you need that, you need my consent, unless what you are doing is sanctioned by the law. Remember, If it is the law that is saying you must file employee returns to NSSF, then the law has told you share all the information about your employee to NSSF. That you don't need my consent. It is the law that says that. If you're supposed to share it with the National Employment Authority, that is the law saying that you do that, and therefore you don't need my consent. But whenever it is not sanctioned by the law, then you require my express consent. And in this case, there are only few exceptions here that express consent may not be required. I've said the first one is a legal obligation that I must supply your information to help if you have a loan. That's a requirement of the law. And therefore there I'm discharging a legal obligation. I don't owe you an explanation and I don't require consent from you. If it is information that is required for either public or health interest, again, we must ask you for your data without seeking your consent. A good example is during COVID-19, where you had no choice but to allow somebody to take your temperature. Normally, you would not allow, because that is your private, they are getting into your private space. But now then you're told you cannot get in until we take your temperature. So that is public interest, that is public health interest, and therefore your right to privacy will be overridden. If you're talking about national security, if you're talking about historical or scientific research, or you're talking about legitimate interest, and here legitimate interest is where maybe you are unwell and we need some of your data to be able to make sure that you given proper treatment, or we contact the right people who could authorize you to be taken through a surgical operation, then here we are saying we are dealing with it, or we are doing that in your legitimate interest, and therefore you cannot say I didn't give consent. Okay, so having said that, I want to point out very quickly again, in the interest of time, about data protection impact assessment. And this is a special requirement under the Act that before you commence taking some kind of data, or if you're an organization that carries out some form of data, either in terms of if they are very, let me use sensitive, is the word I'm looking at. If you're collecting very sensitive data, if you're carrying out a high risk activity, like for instance, if you are collecting data on a large scale, and here, maybe you put in some CCTV that is recording immense data, and you're using some form of technology that has a potential of either being compromised, or somebody could steal it, or it could go to the wrong hands, and you have such immense kind of data there, then you are supposed to carry out a data privacy impact assessment, which is supposed to be a condition for you to be allowed to collect that kind of data. So ask yourself, are you collecting huge amount of data? Are you collecting very sensitive data? And a good example, especially for employers who maybe are doing biometrics or doing CCTVs, that is one of those areas that is envisaged as very sensitive and also big and voluminous. Some data are more risky than others. Like here, for instance, if you're carrying out medical data, for instance, is one of that part that is very sensitive, that may end up exposing vulnerable groups. Like for instance, you want details about people's HIV status or any other medical condition. This is now taken as very sensitive personal data that has very high risk of harming people. Now, if that is what the kind of data you're taking or you're handling, then you must have a data protection, a privacy impact assessment done prior to commencing those processing activities. Yeah, and I will still look at, I've just said all of them mixed together. You're using machines, you're using very sensitive personal data, you're collecting it in very high or large scale, then all those are situations that you may require a DPIA to be carried out prior to commencing of such collection. Again, quickly now to come to your obligation, and I know these are some of the areas that are now also rushing people, given what is happening out there in the media. What are your obligation as a data controller? Those were rights of data subjects. Your obligation, first of all, you must be registered. Again, these are areas that I know for those who are not registered, you should know already you are violating the law and standing a risk of heavy punishment from the Office of the Data Protection Commission. From the onset of these and of this year, and when we got the regulations in place and the Office of the Data Protection Commission in place, that will be around April there. It means if you are not registered, you are in violation of the Act, and it is just a matter of time. So this is part of what, for those who have challenges on how to do this registration. Again, the areas we're able to partner with you. We will give you our information and we can be able to help you comply. It is done through the portal. For those who are able to do it, you can be able to do it online upon payment of requisite data protection safeguards to the Office of the Data Protection. They will review it, and if they find that you should be registered to continue handling that data, they will give you a registration certificate that is renewable every 2 years. Yeah. You should make sure that you are not prompted by a breach for you to put in protection. You should have data protection by design or default. Here, if you have your laptop, just to give a very basic example, if your laptop, before anybody gets access to it, must have a form of protection. By default, it should ask you for your password. It's the same with the phones. It should ask you either patterns, facial recognition, fingerprints, and all that. These are safeguards that are designed inside that machine. So if, for instance, it is about you installing biometrics or the softwares for your payroll and something, by the time you're putting it into commission, it should have those safeguards that are, so in short, when you're having this processor to come and install them, they should first of all demonstrate what they have in place to ensure that the information is tamper-proof. It is not shared, you know, that we're able to hold this information in a way that observes the principles of integrity. I've talked about the DPIA, which is an obligation if you're handling the kind of information that we have talked about. I know in today's globalization, we're having to transfer data across the borders. And here, you should know that you have a duty to get clearance from the Office of the Data Protection Commission if you are processing or sharing information outside the country. And in this case, what the commission would want to know is that the jurisdiction that you're sharing the data to has equivalent data protection regulations or mechanisms similar to what is in Kenya. Otherwise, it does not make sense for us to ensure that you observe the principles of data protection in Kenya, and then you share it to a company to a country that doesn't have the same safeguards, because it means that information can leak out of that country without creating any obligations on it. So that is one of the safeguards that is put in. Jane said, as I said, in the interest of time, I will flip on some of these areas which I know you will read. This is about cross-border transfers, what you have to demonstrate to the Office of the Data Protection Commission before you start sharing your data or even keeping or installing your servers outside the registration. I've talked about the registration process, which I've said you will need to apply. Once you have applied and you have demonstrated all the protocols that are required as safeguards, you have uploaded the requisite documents, your business registration numbers, your annual turnovers you have uploaded. Once you pay, you'll be issued with an invoice which you can pay either on M-Pesa or through other methods that are prescribed there. Then the ODPC will verify the application, And if they are convinced that you have supplied all the information and that your organization has proper policies to make sure that the data is not used inconsistently with the Act, they will issue a registration certificate that will be renewing every 2 years. The amounts are there. I will not ventilate on them. They have classified into small data processors, medium data processors. If you are below 10 employees, no obligation to register unless you are processing some form of data which you must be registered irrespective of the number of employees you have, which I will touch on in a few. But in this case, the cluster is on the number of employees as well as the turnover. Micro, between 1 and 50 employees and below turnovers of 5 million. Medium, between 51 to 99 employees and with turnovers of between 5 million and 50 million. Then you have large scale who are above 100 employees and turnovers of over 50 million. The figures for the amounts for registrations would be there based on those declarations and for renewals. And again, I said I will share for your own purpose. But I've said maybe to explain the between 1 and 10 employees, which I've said there is no obligation to register. There is exceptions where you must still be registered even if you have 1 employee. And this is if you're dealing with organizations that deals with politics, deals with gambling, deals with crime, deals with operations or education, deals with an educational institution. For instance, if you have a school, whether you have 10 employees or 3, you must be registered. If you're dealing with health, you must be registered. If it is a hospitality industry, here you are running a restaurant, here you're running a bar, you are running accommodation facilities, you must be registered irrespective of the number of employees or irrespective of your turnover. Financial services, direct marketing, transport service, if you are running an Uber, even if you just have 1 car and 1 employee, you must be registered because you're in that industry where registration is mandatory. If you're processing genetical data, then it is mandatory, okay? In the next few, to wind up so that we allow time for Q&A, to illustrate this, just to bring into context what has been going all over the media about damages, about penalties for images of minors, using people's images without consent, collecting data without following. Indirect collection, where you are told we are using it or we are collecting for this, but then you find them using for unrelated reason, like I said. Failure to have proper documentation, like for instance here, you are sharing your data with the bank, you're sharing your data with the SACCO, you're sharing your data with the payroll service providers, the CCTV providers, biometrics and all that, but you do not have documents, you do not have written agreements between you and that organization, so that you find that the data end up being misused by that other person that you have shared with. You do not have disclaimers. All these are areas that actually rubbishes the protection that you have put in internally. Because what is the use of you having those data protection policies within your organization? Then you give this information to the bank and you allow the bank to use it for marketing, yet you did not give the information for marketing purposes. They start sharing it because you have not committed them to limit the use for that purpose that you have procured the consent from the data subject. So here is one of the areas during my audits that I found most organizations are failing, that you have good internal mechanism, but then once you share it with a third party, you don't ensure that they are equally bound with your commitments to the data subjects. So watch on that. You have had issues with surveillance, monitoring, tracking. I think I've talked about that. But then we have also seen these penalties that are coming in, and I could share a few. And these are cases for this year, actually, 2023, I think 2 months back. We are all aware of the Casavera Lounge fined 1.8 million because they posted the image of one of the levelers there and placed it on the social media platform without seeking the consent of that person. Just one person who you don't even know, where you have overzealous camera persons taking images of people without seeking their consent. You have placed it in your marketing platforms, in your websites, in your social media platforms. Somebody is not happy. Did you have a written consent from them? The answer is no. You're looking at how much you have lost. And just multiply that by a number of people you have taken their photos without their consent and you have displayed them on that website. These penalties are being given very widely in broad daylight. It is giving people ideas, and therefore you need to relook at how much you have to determine what is your exposure levels. Roma School, again, being charged 4.550. This is 4.5 million shillings. What did they do? This is an educational institution. They took a photo of one of a child who was a minor, and they used it in their platforms without getting consent from their guardian. Remember here, this is a minor. A minor will come and post, but they have no ability to give consent. So don't say alikubali, they are below 18 years, they are minors, protected by the law, and only a consent from their guardian would suffice to have you use their photo and place it on the billboard for marketing purposes. We have these digital credit providers, again charged about 3 million shillings because of calling people. And I'm sure many of you may have been called on this. You are told Mr. XYZ took out some money with us, and now they are not picking their calls, and they had listed you that we should call you in the event they don't pay. And you really feel harassed because nobody asked you, you didn't guarantee, you didn't authorize the number to be given, yet we have these overzealous credit correctors, debt correctors calling you. And one person here was not happy. They took up a complaint with the ODPC, and you can see the consequence. This could have been a loan, 2,000 shillings. But the way you collect, and this is why I told you, look at how you are enforcing your operational needs, your security needs. Here, you have lent 2,000 shillings. You have now, because the person has defaulted, your option is to start calling people right, left, and center. Out of 2,000 shillings, you're paying 3 million because you have violated the right of that person you are harassing that tell your brother to pay. And I know this resonates with many of us who have been called with that kind of a situation. We also have, again, 11th April of this year, we have White Pub and Legas Kenya fined a total of 10 million, again, for breaching the data protection. This is because they mishandled their clients' data. You are having a lot of files there with the client's data. Assuming I'm a law firm, I have client's data. How do I make sure that they are not accessed by an unauthorized person? How do I ensure that they are not shared without their owner's consent? That information could harm people, and therefore I have a duty to ensure that they are kept in consonance with the data protection regulation. Again, huge fines running into millions. Running into millions simply because you don't abide by the principles that we said, and especially the principle of consent. The ODPC has guided that for you to say that they consented, do not imply that because I'm an Ipatia ID, I can now use it for this and this. Consent cannot be implied. You need my photo. It is for this purpose, and I need to give you that consent in writing. And it must be expressed when the wording of the Data Protection Act says must be unequivocal. As in very express, it should not be subject to any other interpretation. Okay, so let us be very clear when we get these consents, either through making up a process, a data protection procedure that in essence tells people the nature of data that are collected of them and how this data may be used, so that you have them sign into the policy that they know that the company has our IDs, has our NHIF, may have some data about our family, and the policy of the company is that that information cannot be shared unless there is consent. That is how they have to come back to us for that written consent. Those are the issues that you will use to demonstrate that you have. First of all, you are adhering to the principles of data protection. Your employees or clients are informed, and ultimately that consent has been procured. That was a marathon of a session. This is a training that usually takes quite a whole day, sometimes even two, depending on the audience. But ideally, I have tried to compress, and I want to believe I have also tried to digest it in a manner that it can be used to digest it and guide investment properly. But then should you require more of the guidance of the same, whether in the registration, whether in coming up with these policies, whether it is in the services of the data protection officer, which maybe I need to just point out very briefly, that it provides that every data controller should designate someone either internally or externally as a data protection officer. The Act does not make it mandatory that you must employ a data protection officer. Indeed, it provides that you can even outsource. Several controllers can use one data protection officer for their purpose. But if you decide to have one internally, your policy must say who is your data protection officer. Your website must tell the world who is your data protection officer. And by the time you designate, the Act provides that that person you have designated as the data protection officer, whose role, among others, would be to ensure that the organization is well guided on matters of data safety, will be the link between the data controller and the Office of the Data Protection Commission in case of a violation, in case of a breach. Remember, some of the breach requires to be reported to the Office of the Data Protection Commission. So the Act provides that the person you designate as the data protection officer must be someone who can demonstrate that they have adequate knowledge on data protection. And this is one area that we fail because we just nominate ourselves without knowing, we nominate ourselves as the data protection officer without appreciating the risk you are assuming. If you have said you are the DPO, make sure that organization is properly advised and it is compliant. If you cannot source that skill internally, then you need to source it externally, where you have another data protection officer who is able now to be the one who is the data protection officer for your organization and therefore responsible to ensure compliance. So that being said, and having left our contacts there, I would want to turn it back to the hosts, just in case there is a question or two. I know we started late and we are short of time. Back to you, Mike, Jen.
Sorry, I don't know whether you can hear me.
Yes, Jen, we can get you, but there's just maybe a small echo. Yes, okay, Jen, I can assist you. I think I can proceed, but if I have a challenge, I think I'll throw it back to you. So thank you, Peter Kinyanjui, for that engaging and very insightful session. If we look at some of the questions that have been posted, one, Yvonne Achita says, so an employer is to register as both data controller and processor. That's a question to you, Mr. Peter Wakili.
Thank you for that. The answer is no. You only register as a data controller and processor if you are carrying out both activities. I would say this to be on the safe, that mostly every organization will be required to register as a data controller, but you only register as a data processor if you carry out processing activities on behalf of another controller. So yes, I wouldn't say that you should register as both, but yes, you may be required to register as both if you have information you gather for your own purpose, but then you're also an agent. Let me give an example. Like, assuming you are running an employment agency, and in that agency you have 20 employees. Now you will collect this data from the employees for your own purpose, meaning you are a data controller because you are an employee. But at the same time, you recruit for people, meaning you ask for CVs for a certain position, you do the shortlisting, and eventually give maybe a shortlist to the client. In this case, there are 100 CVs you have invited for a certain position. You are simply acting as a processor, as procured by a certain data controller who may be another employer who wants to employ a HR practitioner but has procured you to do the advertisement and the interviewing and all that. So I hope that is clear that in this case, this HR agency is both a processor and a controller. But normally many of us as employers, we are simply controllers only, and others are specifically processors only. Thank you.
Okay, thank you, Peter. The other question from Frida Gujiri, kindly clarify if the HR is the one who is a data controller for payroll processing, so that also a data processor who should register the HR or the company. And I think this one you mentioned, I think it is the company that needs to be registered as the data controller, and the staff are working as just agents of the data controller, which is the company. I think that is pretty straightforward. So John O asks, so how can a male staff demonstrate that the child is his? I don't know where this was also emanating from, but maybe you can try to answer this.
I want to believe that came in from the paternity administration of paternity leave. And here, I think what is coming up here is that one of the way employers have used is to ask them to is only to give paternity if it is a child from a spouse registered with the company's record. And what I was saying is how the law Employment Act avoids that mischief or abuse is by capping that a male employee is only entitled to a maximum of 14 days per year. Yeah, not by the spouse that is registered and all that. So, but it is them to demonstrate that they are the father. The only part I was taking a deviation is that they must not have gotten that baby with the husband, with the wife who is registered in your record. It could be someone else and they're still entitled as long as they can prove they are the father. Back to you.
I think that's it.
Okay, sorry, I'm in a noisy place. Jen, maybe just pick up on the questions, tafadhali.
On my end also, I'm struggling with echoes. Mike?
Okay.
Perhaps
we can continue. Yes.
Perhaps I can be able to read just a few from what is reflected on my end.
Okay, thank you. Please proceed.
I can see from Romeo here that based on the examples of CVs sent for a vacancy, how is it discarded when the applications were sent via email? Do you delete the emails sent, or it's just, here is more or less what do you do with these CVs? How is it discarded? And yes, part of it is the deleting of emails is part of the principles of data protection about how do you, we are calling it storage limitation. How do you delete and ensure that they cannot be accessed by someone? So one of it is you delete. The other is where if you had printed, they are physical, again, you have to destroy once the purpose have been achieved. And if you go and look at this act and also the corresponding European through the GDPR, you'll find that they actually even give you ways of discarding, like assuming you want to sell that laptop after it has served its purpose. Still, there will be a procedure that ensures that it doesn't go to a third party who is able to retrieve data from it. So here, deletion maybe is a process in itself, but the key should be to make sure that it cannot be retrieved or gained access by someone who was not authorized to get it. There is one from Christine that when you're sharing data to a third party, maybe a medical service provider, do you need to have them sign a policy document indicating that the data will be used for Yes, that's the disclaimer we are talking about. Again, if you come to us, we can be able to show you some of those standard disclaimers. For anybody you are giving data belonging to your people, they have to sign that they will not use it for any other purpose than which you have given it to them. That will remove responsibility from your end if it is demonstrated that it is this other controller or this other processor that misused the data. When an employee asks for a file to view, is that in order? Yes, right to access. Let the employee look at their file in a controlled environment. That is the only way they will tell you, please update this information so they have a right to access. John is saying that the express instruction from employee to an employer representative for a change of particulars, should it be written or verbal? We have simply said consent. Whichever consent that you're seeking must be expressed in writing and very specific. It should not be left for assumption. So whatever documents, as long as the effect of that is to get consent, ensure it is in writing and very express. Abdul Karim, you're saying that with the automation of government system, you realize most job applications are nowadays done online, especially with job keepers or registrations, membership bodies through portals. How secure are these platforms, especially when you don't get shortlisted or rather the job altogether following? Yes, again, from Migori, what you're saying is whatever platforms that you are now using, whether you are applying online, under the principle of integrity, it must ensure that that information is kept and only used consistently with that particular purpose. And indeed, it is discarded once the purpose has been discharged. If anyone is to access that information through a breach, that is what will be called, is defined as a breach. And whoever was using that platform will be liable for any information that is shared and used inconsistently. So again, it's good to check. And if you look at most of those filing, those platforms, they will always have those disclaimers there that requires you to sign in, to check in some box. In checking those boxes, you are giving consent. So when you come to the electronics, the consent you are talking about is not one that you type in, but just a check where you're saying, I have read, I have understood that I'm giving this, and you have given consent. Look at these apps that you are downloading every time. The app will tell you that this app requires to access your gallery, and they ask you to accept. If you don't accept, they cannot allow you to install that app. That is one way of getting an express consent from you. because they are saying we need to access your photo gallery. You have said yes. Now, if you find those photos in your phone have been taken by that party and they are used out there and they harm someone, the third party will say that you are the one who gave the consent, and they will demonstrate that you signed that agreement, even if it is electronic. Yeah, some are to the secretariats about the recordings, if they can have it, that is okay. We can. Maybe in the interest of time, I would still, having left my email, if there is still any area that may not have been ventilated very well, kindly drop an email or do a call. I can be able to ventilate on it more. And if you have any specific engagements, assignments, we are ready to partner with the organizations to assist you in the compliance. In the interest of time, take it back to.
Maybe Peter, before you close off, there is I have seen immediately after that case that went to Casavera, most of the clubs now decided to just put a blanket statement that by you entering these premises, this place, they are taking photographs and the photographs will be used for marketing. So how does that, can that be able to cover maybe the organization? Because I know other companies will now feel like, okay, well, let us put a notice on our entrances that this place we are taking photographs and they'll be used for this and this. How effective is that?
Yeah, it is not effective. Just by telling people that you come in here, you will know we will take photos. That looks like bossing on people rather than seeking express consent. In fact, those kind of seeking consent is actually against the act. The consent should be that we are taking your photo. And you've seen these in websites, in maybe facilities that you attend. It is in the positive that we have gotten this information. We are going to use it for this and this purpose. Please sign if you are agreeable. You see here, I am seeking consent, not telling you that by coming in, then no, we will take photos and we can use it for our marketing. That will not suffice. So that disclaimer will not help that restaurant at all. Thank you.
Kenyanjui, just before we let you go, allow me to ask one that I think is relevant to most of the HRs, and it's on collection of employee background checks. So with these limitations, there is that question of, are we now allowed to, or is there such limitations that this is no longer a go zone?
Kindly repeat that, Jen. I lost you at some point.
So let me get that particular question. Someone has asked about are we allowed to do how best can you do background and reference checks now that we have BPA in force?
Okay. How you do a background, first of all, you must inform. We said the data subject has a right to be informed. You have to tell someone that we will be contacting XYZ. Do you authorize us to do that? And they have to sign it. Now, in one of the cases that I know has been taking rounds is where one of the employee was actually denied a job because the reference gave something negative, and therefore he was denied, and he went to court, and he was able to, he came back to the company and he was telling the company, I need to know what this reference check yielded and why since it ended in denying me a job, I want to know what you are told. And the courts were very clear that they have a right to be given that information. So the consent express that you're doing this, but then also know that information about that employee that you have gotten, the employee has a right, or the prospective candidate has a right to access it. So in short, tunasema tusifanye vitu mbaya mbaya huko, in the pretext that you know is a background and you have used it to make decisions of people, and you tell this person that you are not entitled. It is confidential. There is nothing confidential about my data. I should know that he said that I did this, or I didn't do this, or I'm not this and that, so that I can be able to tell whether it's actually true, whether it is accurate, or I should have been given an opportunity to say that that was malicious. It is just my former employer who doesn't want to see my success or something. That's it can occasion injustice, and that's why it should be very clear, very express.
Thank you. The last one, we are 1 minute to our time. Someone has asked, is it right to ask a candidate who was successful for an interview for their payslip from their current employer?
I would say yes. Here you're asking for consent. You're telling them, do you let me? I would want to see. You see, that is very express, and they have given to you. So they have given consent. Once you give consent, you cannot complain later.
Okay. And someone else has an interesting one here, and he says, a case where you encounter a crime scene of a person stealing, and you decide to take a video or a photo as an evidence, can that be used against you?
Again, if you're saying if someone does that, Jen, sorry?
If someone uses their phone to record a crime scene, can that be used against them now that they recorded without the consent of the criminal?
And no, those are some of the areas we have said that in some cases, national interest prevail. In some cases, public interest or public health, prevails. So that if what is obtained without your consent is something that serves a wider, bigger purpose of the population, then your consent doesn't matter.
Okay. So I think we are right on time, and we can leave it at there. So ours from the Institute of Human Resource Management, we are the Mount Kenya branch, is to appreciate the Institute for sponsoring this. And our counsel, Mr. Kinyanjui, you have well articulated from most of our participants. They are very enlightened and they are excited, and they've gathered quite a lot from this session. For our participants, we were up to around 165. We thank each and every one of you who participated, and we look forward to hosting more and more as a branch, Mount Kenya South Branch. And from our end is to thank you and to wish you a lovely holiday ahead. Thank you so much.
Thank you. Have a good holiday, good long weekend ahead. I will share my notes with the secretariats. Perhaps they will find a way of pushing them over to the participants. Bye.
Thank you. Bye all.
Bye, everyone.